Today represents a great day for California. It represents a great day for the United States and for all of the people of the United States. The United States Supreme Court today made clear that Proposition 8 is unconstitutional. What we have argued all along, in reference to the 14 times the United States Supreme Court has found marriage to be a fundamental right, is that when Prop 8 denied same-sex couples their right to marry, their right to express their love in a way that would be recognized by the law, it was against the very founding principles of our country. It denied them equal protection and due process, and for that reason should be banned and should not be allowed in this great state of California. Today, the United States Supreme Court made a ruling based on the arguments we have been making all along. The proponents of Proposition 8 did not have standing. What does that mean? It means those people who want to deny same-sex couples the benefits of equal protection and due process under the United States Constitution cannot do so simply because they don't like the notion. The United States Supreme Court, in essence, declared today they are bystanders. They are sitting in the sidelines. They can have their freedom of expression, but they cannot deny Americans, they cannot deny citizens of this country equal protection and due process under the law. Today is a great day for our country. Today is a day not unlike everything we did when we passed the Civil Rights Act, when we passed laws that say that all people are created equal. Today is a day that reaffirms our commitment as a country to giving every person equal protection and due process under the law. I sent a letter to the governor outlining our position on this matter, and essentially this letter, which the governor received from me as his lawyer, outlines the law of the land in California and our interpretation of it. And what we have basically given the governor and the Department of Public Health is advice based on the law in California and the law of the United States that the 58 counties of the state of California must abide by the ruling of Vaughn Walker from the district court when the stay is lifted and must commence marriages in California. I am also calling on the Ninth Circuit today to urge them in the strongest terms that they lift the stay and enforce the permanent injunction that Vaughn Walker outlined so that marriages can begin in California immediately. We have outlined in the many briefs that we have filed before the various courts of this land, including the United States Supreme Court, that each day is not equal when it comes to individuals' civil liberties and civil rights. Each day that passes when any individual is denied their civil liberties and civil rights is a sad day in our country and certainly in our state. And we know that these same-sex couples have been denied equal protection under the law for far too long. And each one of those days that has passed has been a day that a family member who may have enjoyed and participated in a wedding ceremony may have passed away. Each day that has passed is a day that a baby may have been born. And that California child then is in a situation where they don't have the full dignity that other children have when they look up and they ask, why can't my mommies or daddies be married also? We cannot delay or deny individuals their civil rights. And for that reason, again, I urge the Ninth Circuit to lift the stay as quickly as possible. Today is a great day in our country because also the United States Supreme Court found unconstitutional the Defense of Marriage Act and found it unconstitutional on very, again, basic principles outlined in our Constitution. And the concept is this: It's called equal protection. It's that all people should be treated equally and fairly under the law. The decision in DOMA was exactly the right decision for the court to make, understanding that people like Mrs. Windsor had been unfairly treated when denied benefits under the federal law. In that case, it dealt with taxes. But let's remember all the benefits we're talking about that others of us otherwise enjoy. Benefits that come with Social Security, benefits for those who serve in our military to receive all of the support that they rightly deserve. Today is a great day in our country when the decision came down on DOMA saying that it is unconstitutional, and I applaud the United States Supreme Court for its decision in that matter. In closing, and then I'll take questions, I'll say that I think that that we as Californians should be very proud. We are a golden great state. And I know that all Californians, as evidenced by the most recent polling that was done, 61% support same-sex marriage and the right of these couples to marry as equals under the law. We have approximately in California 50,000 children who are the children of these same-sex couples. And today, hopefully those little boys and girls are wherever they are in summer camp or hanging out because school's obviously out. Hopefully they are celebrating with their parents, understanding that they are equal to all and inferior to none. And by the ruling that we have today, I know that we as Californians will continue to do the work that we have always done in fighting for civil rights and civil liberties. So I thank you, and I'm happy to answer any questions. Yes.
This is outside the purview of your responsibility as the chief law enforcement officer of the state, but you mentioned the poll there.
Yeah.
Give us the measure. You've gone around the state since Prop 8. Give us the temperature, the measure of public opinion based on your observation.
Yeah.
Prop 8, if it were on the ballot again today, would it have the kind of support it had 4 years ago? And have you seen a sea change in public opinion? People just want this over with.
So I'll tell you my personal connection with this, long-standing in terms of fighting for and believing that the LGBT community should receive equal treatment under the law. But on this specific issue of marriage, I'll tell you, on February 14th, 2004, I was in San Francisco that morning on my way to L.A. And the marriages started. And I was literally on my way to the airport, and I said, I can't leave without going by City Hall. And I drove up to City Hall, and it was the most extraordinary sight you've seen. There were literally families, children, elder people, wrapped around this huge city block. There were balloons. The energy that was coming out of this crowd was, you could feel it. It was tangible. And I jumped out of the car. I said, I got to be a part of this. I walked up the front steps, and in fact, there was the assessor at the time, and she said, Kamala, I need some help. Can you help us marry some people? And I said, sure. And I actually performed some marriages that day before I came to LA to have, the rest of my day. And it was an extraordinary experience. And what I saw there were people, human beings, families, productive people, good people, who just were so excited that they could have the legitimacy that any one of us can have in having our loving relationships and bonds being recognized by law. And I think after that day, and certainly over the course of the last several years, even post-passage of Prop 8, which was in 2008, more and more Californians and Americans are starting to understand that these couples are their family members and their neighbors, and people who are leaders in the community, people who are otherwise in every way respected and are role models. And that we cannot, if we are a civil society, treat them differently because of the choices they make about who they love and want to marry. And so on this subject, to your question, I think over a period of time, quickly, people are starting to realize that a civil society, this is not a mark of a civil society, to have prejudice or bias or unequal treatment against a group of people because they make choices about who they want to marry that may not be the choices that one might personally make. And so I think it's quickly changing. And I was just with my goddaughter this morning. She's 8 years old. And I was jubilant explaining to her this decision, and she was like, Auntie Kamala, but why can't they anyway? I don't get it. This is going to change when my 8-year-old goddaughter, Helena, is of voting age. I will tell you, we'll see a drastic sea change, and they're going to all look back at us and say, how could it be that there was once a law that denied these folks equal protection? I'm sure of it.
All right, Robert Levine with ABC7. You know, you mentioned you're asking the Ninth Circuit to lift the stay.
Yes.
Are there any reasons, do you have any reason to believe that there could be delays in them lifting the stay? And then secondly, upon the stay being lifted, do you expect that there could be county clerks in the state that might deny marriage certificates?
Right. So, at the expense of being a law professor here, so there is a Supreme Court rule that basically says that, so back up. Today, the United States Supreme Court, they issued a ruling. And so the ruling is on DOMA and on Prop 8. DOMA, that it's unconstitutional. Prop 8, no standing, so it goes back to the Ninth Circuit. It's not a judgment, it's a ruling. The judgment, the legal impact then, has to wait 25 days. So there's a rule of court, basically, a Supreme Court rule that says you have to wait 25 days. And that's for, you know, just to let the process take place. And then, after that 25 days, the judgment will issue, and then it would go to the Ninth Circuit and say, this is our judgment. So there could potentially be that delay of 25 days. Our point is the Ninth Circuit Court of Appeals has it within its power an ability to lift the stay before the judgment comes down. And so what I am asking specifically is that the Ninth Circuit lift its stay. So when the Ninth Circuit does that, the remaining rule, the remaining law of the land for California are the words of Judge Von Walker, who said under equal protection and due process, Prop 8 is unconstitutional, and therefore every of the 58 counties will be enjoined from enforcing this unconstitutional law. Enjoined meaning they will be prohibited from enforcing a law that is unconstitutional. And what is the authority behind that? Well, I've got 3 pieces of information that tell you, again, it may be too much for all you, but I think you'll appreciate it. So the first part is that the specific language in Judge Walker's ruling was that the defendants, right, so that at the time were the counties, in their official capacities, and all persons under the control or supervision of them are permanently enjoined from enforcing Prop 8. Okay? So that was his explicit language. So that meant the governor, the Department of Public Health, the Attorney General were enjoined, and all people under their jurisdiction. The counties are under their jurisdiction for the purposes of this, and in particular under the jurisdiction of the Department of Public Health, which is why I issued this letter reminding them of that. So the Department of Health, being one of the people specifically told by Judge Walker that you guys cannot enforce Prop 8, now must tell the people that they supervise, because Judge Walker told them to, you guys can't do this. And so it is our opinion based on that, based on the fact that there's a case called Lockyer that basically said that, and remember that was about marriages also, that the counties cannot enforce they can't enforce arbitrarily the law because they are state officers. They work under the guidance of the state. They're agents of the state. So they have to do whatever the state is required to do. And then there's Rule 65, which is a federal rule, which basically makes the same point, which is that you got to do what your supervisor tells you. And so for that reason, so that's the legal basis, but for that reason, I am absolutely certain and sure that our analysis on this is correct, which is that each of the 58 counties of the state of California has to follow the ruling of Judge Von Walker, which says that this is unconstitutional. You are enjoined from permanently, he wrote in his opinion, permanently enjoined from enforcing Proposition 8, an unconstitutional law. Yes?
Simon Bowie, CBS News. I have my own question, but I have a follow-up to his question. So are you saying that if the Ninth Circuit releases their stay of their hold prior to the 25 days of SCOTUS that marriages could resume before the 25 days?
Yes,
Is that what you
I am.
said?
Yes, I am.
Okay.
I am absolutely saying that if the Ninth Circuit lifts its stay before the 25 days, that marriages can resume in California and shall resume in
So
California.
literally, if the Ninth Circuit decide to act this week, marriages could resume Monday, theoretically?
As soon as they lift that stay, marriages are on.
Okay, well, thank you for the clarity.
The wedding bells will ring.
Now to my question. The court in this decision, like you said, their nullifying Prop 8 was because of standing.
Yeah.
But they didn't go as far as, this was not a Brown decision. This was not a Loving decision. They did not make the law for the entire nation. What are your thoughts about that?
Well, first, I think that it's really important that we just celebrate today. And this is a huge victory for California and for same-sex couples and for Americans. Today is a day for celebration. Today we should declare victory. And it has always been our belief as a state of California, it has always been my belief as the Attorney General of the state who otherwise could have defended Proposition 8, that Proposition 8 was unconstitutional and for that reason should not be defended. And going forward, let's remember that the reigning legal opinion, the reigning law, as found by a judge on a federal analysis about the federal Constitution, is that Proposition 8 is unconstitutional. Because the law of the land in California, because of the ruling of the United States Supreme Court, is the law as declared by Judge Vaughn Walker, who found after a 3-week trial, he didn't just from the bench say these things based on some opinion. He held a trial. He heard testimony. And on the basis then of the facts and the evidence presented, he found Proposition 8 to be unconstitutional. And I would venture to say, implicit in that, is he found the arguments in favor of Proposition 8 to be bogus and without merit.
And one final question. I promise to get the mic up.
Deal with them on that.
This one is about DOMA. This is specifically about taxation as it relates to DOMA. It's my understanding that people can go back 3 years and file an amended tax return. With the DOMA decision today, does that mean that DOMA is unconstitutional as of today, or has DOMA always been unconstitutional and therefore people who have been living together in domestic partnerships can go back 3 years and refile those tax returns as married couples? Will they have that right?
I have not done that analysis yet to tell you, but I'm sure that there will be differing opinions on that and probably some litigation around it. We'll see. I haven't done the analysis on that specific point yet.
I know you said today's a day to celebrate, but is there any door left open for those who know how to manipulate things and write things, that another Prop 8 measure or something down the line will pop up one day? In other words, this is not a Roe v. Wade type of decision.
Yeah, I think that, of course, it'd be so cliche, anything is possible. But I would also suggest to you, and just referencing back to an earlier question, that it won't happen in California again. I'm certain of that.
Why?
Because Californians don't want that kind of discrimination and laws that discriminate against people who otherwise should be treated as equals. Proposition 8 will never be passed again in California. I am certain of that. And I will do everything in my personal power to make sure it wouldn't.
Yeah, hi, Greg Risling from AP.
Hi.
You did mention that you didn't defend Prop 8 because it was unconstitutional in
Correct.
court. Do you believe that's a bad policy, and would you do it again with a voter-approved measure with something that you didn't agree on?
No, I believe not defending Proposition 8 was the right thing to do. And you may recall that, because I think your question really does ask for this information as well. I was elected in November of 2010. And in that general election, there were clear differences between me and my opponent. And this was one of them. My opponent said he would defend Proposition 8, and I said I would not. I was elected.
Hi. I'm sorry. Hi. It's Ben Bergman from KPCC. I was wondering if you're concerned at all that there will be some county clerks who do not abide by Judge Walker's ruling and do not issue marriage licenses, and in that event, what you would do.
In the unlikely, I hope, event that any county decided to violate the law and not enforce the injunction, then we will take legal action, because they'll be in violation of the law. And I am the chief law enforcement officer of this state. I'm also the chief law officer of this state. And we have done an incredible amount of work outlining the law based on legal analysis and based on court precedent, and that is that. And on that point, I can't stop talking about this case this morning without recognizing in their absence two individuals who are some of the most hardworking career public servants who have, at great personal sacrifice and great professional responsibility, done the work in California of seeing this through the courts, and that's supervising Deputy AG Tamar Pachter, P-A-C-H-T-E-R, and Deputy Attorney General Daniel Powell. They really deserve recognition for their incredible work.
For a follow-up to that, though, do you have any information whatsoever that any city county clerk in any of the 58 counties has expressed reluctance to abide by this? Do you have any information to that?
I've not received any word this morning that anyone has any reluctance, and you know, I would assume that each one of them, in fact, I know that the Department of Public Health has sent a letter and attached my letter to Governor Brown, instructing them that once the stay is lifted, they are to commence with the marriages. So they are on constructive, if not actual, notice that the law is that when the stay is lifted, they must begin marriages. And again, I would like to believe and hope that none of them has any intention to violate the law.
There's an implication that you believe that's a possibility. I mean, rarely do we hear somebody instruct 58 counties to obey state law.
Yeah, well, you know, I'm a career prosecutor, as you know. I like to believe that the vast majority of people want to follow the law, and because it's the right thing to do, but also because they know there are consequences if they don't.
One more question.
Just on the
I'm letting her.
With the asking to avoid the 25-day delay. Do you personally, or will someone personally go in front of the court and ask that? Do you do a writing? You send a letter? Or is this your plea and they'll hear it?
This is my plea, and I believe they'll hear it. Yeah, and I think it's just the right thing to do. And I think, you know, we'll see. It's going to be an interesting day. I mean, we've all, those of us who are so close to this issue, we've been in these rooms and together right now. But I think as we go out on the streets and spend the day today and over the course of the weekend, I think we're going to see that there are a lot of people that are extremely excited about this, and that they want it to happen now, and that they're excited because the court has finally, the last ruling has validated something that is just the right thing to do. And I think that we have to realize that the celebration can't be only because something was spoken in court. It has to be because those words that were spoken in court have impact and effect on the street level. And that means not just celebrating that the court said something, but recognizing they said something with the intention that we would do something. And doing something means allowing these couples to marry.
Hi, Dana Feldman with Reuters.
Hi.
So if the stay is lifted, what is the soonest that people could get married feasibly?
Oh, I mean, you know, as soon as possible, I'd like to say. I mean, you know, realistically, I don't know. I mean, I don't think it would happen today, and it would probably take at least a couple of days. But I'm hoping that it will happen much sooner than 25 days from now. Yeah.
Thank you all.
Thank you very much.
Thank you.
This was personal for you, wasn't it?
Yeah, I think it's personal for all of us. You know, again, I'm a career prosecutor. So let me just tell you the way we have designed our law. When we say that we are taking a case, whenever my office takes on a case, we do it in the name of the people of the state of California. We don't do it based on this person against that person. We do it as the people of the state of California, because underlining our very basic notions of justice is the point that when there's an offense against any one of us, it's an offense against all of us. It's basic to a fundamental notion of justice. And so on this issue, when you have a group of people who are being denied justice, that's like each one of us being denied justice. And I think in that way we should all feel that this is a victory for us personally and for our larger community and society. Yeah. So that's up to her. She's the boss.
Just one more quick question. You're now the Attorney General. You were the Attorney General of the nation's largest state before this, but now the largest state in the union that allows gay marriage.
That's right.
Have other Attorney Generals or other officials in other states sought counsel from you? Have you offered advice? Will you be offering advice to states where they may have not gotten as far as we are today to help them navigate those waters?
Yeah, definitely, and we are very collaborative, the attorneys general of the state, and I work very actively with the National Association of Attorneys General. So that the answer is yes. The short answer is yes.